Hello, I'm attorney Tammy Saltzman, and you are watching Divorce Connection Network. Today, I'm so pleased to introduce to you to a very dear friend of mine, Carol Gart. Hi, Carol.
Hi, Tammy.
Welcome.
Thank you. Glad to be here.
I'm so glad to have you. Carol has been practicing 30 years here in Boca Raton. She has a law practice named Carol A. Gart, and her focus in her practice is appeals. So, many of you cannot settle your cases. You go to trial, and you're hoping that you're going to get justice in the courts. And then, after days of trial, you get an order from the judge, and you are not happy. And you say to your attorney, I want to appeal this order. So, you would hire someone like Carol. So, Carol, tell the audience, what kinds of cases are appealable?
So basically, when you get to the end of a case, you've got a final judgment. The judge has decided a number of things in your case, may have decided something about your prenuptial agreement if you had one, decided on alimony, decided on time sharing and visitation, custody, child support, things like that. So that final order is an appealable order.
So a final order is appealable?
Yes.
Always?
A final order is appealable, yes.
And how long after the order is signed by the judge does someone have the right to make an appeal?
So that's the key part. You have 30 days from the date of the order. Now that 30 days could be extended given certain motions that might be filed at the end of the case, but there are technical issues regarding that, and best left to the attorney who discuss that with your attorney. Just keep in mind it's 30 days from the date of the order. Use that as your rule of thumb. It may be extended for a certain reason, but just keep that 30 days in mind because you need to start thinking about hiring an appellate lawyer if you want to go that route.
Right. Not all family law attorneys do their own appeals. I don't do appeals, and I don't do domestic violence issues. I refer those to criminal attorneys. So I believe that there are certain things that require a specialization, and you can get certified as an appellate lawyer, you can get certified as a family lawyer, and then there are lawyers that just do appeals or just do family law without special types of certifications. So within that 30-day period, someone will retain you, and then you start to do research on how the court may have made an error, correct?
Yes, exactly.
So what makes, not every order, I would imagine, is appealable. Like, are there times that you look at something and you say, I don't really think that you're going to win on appeal?
Yes, and exactly. And that's what a good appellate practitioner should be able to help you sort out. Because one of the most important things about an appeal is the standard of review. That's the way in which the appellate court will be looking at the case. And if you have a case that was decided that warrants what's called a de novo review, that means the appellate court is going to look at it with fresh eyes, and you have the best chance of success in that kind of case. But if you have a case where it's up to the discretion of the judge, certain things like child custody or relocation, different things like that, temporary attorney's fees or entitlement to attorney's fees, things like that are discretionary with the trial court, and the appellate courts are going to be reluctant to overturn such a decision. They will generally only do so if no reasonable person would make the decision that judge made. So you have to think about that when you are appealing a case where it is a discretionary call on the part of the trial judge. You could end up spending a lot of money for something that you're not going to get much return on.
So what makes a final judgment, ripe for a de novo review?
So it would be something like interpretation of a prenuptial or antenuptial agreement, because a contract interpretation is reviewed what's called de novo.
Okay.
If the judge applied the wrong law to your case, say they decided to apply an old statute instead of the new statute that was enacted, something like that. So it's a question.
Or if they misapplied the statute?
Misapplied, mm-hmm. Yes, that too. But if the judge applied the statute correctly and took testimony, heard evidence, and decided, well, I believe you as opposed to you, the appellate court is not going to look behind that. They're going to say, well, the judge was the one who was there. Listening to the evidence, and we're going to go with what this judge said. We're not going to overturn that decision.
Sometimes I see cases when I'm reading, case law, and I'm looking for case law and how things were decided in the past in order to give clients advice. And sometimes I'll see things reversed because the lower court failed to use the statute to explain why they did a certain equitable distribution or why they gave the spouse alimony. Like, they don't totally describe the need of the spouse receiving it and the ability of the spouse to pay. It seems like those types of things. So if the judge went quickly and didn't use detail, sometimes those are reversed or remanded back down for more explanation.
Right. There are certain statutes that, and especially in the family law arena, that require the court to go through certain steps before they make a decision and consider certain factors. And if the trial judge did not do that in the way that the court requires, or the statute requires, then yes, the appellate court will reverse and remand for the court to make those findings. And
does the appellate court, always reverse the decision, or do they sometimes send it back down and say, just do further explanation, please?
Well, either way, it would be a reversal.
Okay.
So in certain circumstances, they might say, trial judge, just explain your decision, or in certain circumstances, they might say, you need a new trial. But once you've already put in all of the evidence, that is unlikely in that kind of circumstance.
Right. I would imagine having to take another trial would be extremely costly for the clients.
Right.
I would imagine that to be in very rare circumstances.
Right. Well, that could happen because if you have a case where in the rare circumstance where the appellate court says, well, trial judge, you abused your discretion in deciding this custody award or in deciding this alimony award or things of that nature, then yes, there would be a new trial instead of reviewing the prior evidence.
What approximate does it cost to have an appellate brief prepared and submitted to the upper court?
Well, it depends, of course. And also it depends on where you are in the proceedings, because we talked about appeals from a final judgment, but there also could be appeals from a non-final order that was entered in the process of your case, such as a non-final order for temporary custody, non-final temporary attorney's fee order, things of that. There are certain things that can be appealed immediately while the case is going on. So those would be a little shorter because the record is smaller. You've got motions, you've got a shorter hearing, you've got less discovery involved. For a final appeal, it could run easily. If you are the appellant, you're writing an initial brief and you are writing a reply brief, could run $20,000 easily, if not more, depending on how long the record is, how long the trial was, how much evidence was involved, how many different issues, how many things you're complaining about in the order. So it's very costly.
Do you have to go before the court and argue your brief?
Some cases are argued. The appellate courts decide whether or not they will grant oral argument. You can request it. You don't have to request it, but if you don't, the other side might. And I always recommend to request oral argument because I always feel as though there might be some question that the appellate court might have that you want to be able to further explain if they're asking a question.
Okay, great. So let's just go back and review for a moment. So we talked briefly about temporary orders. Initially, when you come to an attorney, you may only have enough money for a retainer, and you might need more money for discovery or for depositions, and you have no additional funds to pay the lawyer. So the lawyer would do a motion for temporary relief for attorney's fees. It could be that your spouse has bailed out and you need child support, or you say one spouse won't allow you access to your children. So the attorney who represents you will do motions before the court trying to get temporary orders in place to give you child support, to give you visitation rights, to give you money for attorney's fees so you can have equal footing in the court. If you do not like the decision made by the court during those temporary hearings, the motions, then those can also be appealed.
Right. They can also be appealed. And keep in mind, most of those orders are discretionary calls with the trial judge, so difficult to overturn.
Difficult to overturn again. Okay, so I want to thank you for joining us today, and I want you to be able to find Carol on our website at divorceconnectionnetwork.com, and we look forward to seeing you again. Thanks so much for joining us.
Thank you, Tammy. It was my pleasure.
Bye-bye now.